Okay, and without further ado, I present Megan Hennigan, one of the attorneys here for today's Ethics Forum. Thank you for joining us.
All right, good afternoon, everybody. My name is Megan Hennigan, and as most of you know, I'm the Deputy Director of Education here at the Joint Commission on Public Ethics. Erin Lynch, who is, well, she has a new title now. She's Associate Counsel. She's kind of going over to the lobbying side soon, or is there now, but she's helping me on this last ethics forum today. She's going to co-present this with me today, and also Keith St. John, who's the Director of Ethics, is here as well. So mostly we're going to focus on 73.4 today, which is the section of the law which tells what state officers can and cannot do if they want to have a contract with the state. And I'm going to set the stage here on the next slide. All right, so here's just a few questions to set the stage of where we're going today. So has an employee sought approval to enter into a contract with a state agency? And if and when this has happened, what kind of questions do you ask when you get that request? And for outside activity approvals, have you encountered an employee specifically seeking approval to enter into a sole or a single source contract with a state agency? Do you communicate with your agency's procurement department and their employees to talk about how Public Officers Law Section 73.4 might affect the approval of certain contracts with your agency? Do they know what to look for when reviewing these bids? So again, just questions to kind of get your mind set to see where we're going today. Just a quick topic overview of the areas we're going to touch upon today. So the first section, we're going to be talking about understanding issues arising from the Public Officers Law Section 73 and other laws that are going to intersect with 73.4 in particular. We'll talk about Public Officers Law 73.4, 73.7, 73.15, I believe, and also the Code of Ethics in 74. We'll touch upon state finance law and get into quite a depth of a few advisory opinions that touch on all these issues, and also JCOPE enforcement actions. In the second part of this, we'll get into spotting questionable business practices. So what resources are already out there for agencies? What do agencies already do that I could tell on my research? And what can they do? So we have some ideas that we're going to present later of things that you might want to think about. And finally, analyzing hypothetical scenarios. I'm a little upset we didn't get any hypothetical questions from you all this time, but we threw in a couple at the end. And I'm hoping, as always, at these forums that as we go along here, bring up your questions as we go through or at the end, whatever, and we will start chatting about questions you may have once we get into this. All right, the first area, which is going to go all the way through, we'll talk about 73.4a. So this is the gist of that law. It permits a state officer employee or a company owned or controlled by a state officer employee prohibits them from selling goods or services to a state agency only if there's an award or contract issued after public notice of competitive bidding. So for example, a state trooper recently won a competitive bid for snow removal from OPWDD residential properties. It was competitively bid out. It was awarded because it was fined under 73.4. And as we get into this a little bit further, I know it might also be okay if he or she had won a bid from his own or her own agency, but there have to be certain parameters in place after that. So we will get into that in a few minutes. So what other laws do we need to think about? The first one is state finance law. And we're going to look at State Finance Law, Section 163. So there's a lot in 163. We're not going to sit here and talk about it all day. But the State Finance Law does not require a state agency to bid a contract for goods or services in all circumstances. So here are just a few examples. For instance, a sole source procurement is one in which only one vendor can supply the commodities or the technology or the services required by the agency. And so the agency seeks those services through what's called a sole source memorandum. Single source, similar, where there's two or more vendors that could supply it, but the state agency selects one over the other for certain reasons, and they say such as expertise or previous experience with similar contracts. So state finance law allows for these different kinds of bids that are not going to always be that traditional bid out and put it in the contract reporter. Right? However, if you want to note this, actually this will be online later, our presentation, but 92.2 is an advisory opinion that is great to reference. This where it specifically talks about the state finance law, this section, and 73.4. So even though we have all these we have the section, the state finance law that says, yes, the state can put out a contract and do a sole source or a single source, then there might be other ones. 73.4 nonetheless prohibits a state officer or employee from entering into no-bid contracts with any state agency. So even though these things are allowed under the state finance law, 73.4 trumps the state finance law, and in so many words, 92.2 says that. So state officers and employees may not enter into single source, sole source, or any other non-bid contracts with a state agency. Okay, we'll get into 73.7. How does 73.7 interplay with 73.4? This is a section, and I'm going to only focus on that first section first. So this is when we're talking about contracting for goods or services with the state. This is the section which says state officers and employees are prohibited from being paid for appearing or rendering services before a state agency in connection with. So this is A1, the purchase, sale, rental, or lease of real property, goods, or services, or a contract from, to, with state agency, okay? So when these two subdivisions are read together, in order to harmonize their meaning, it basically then, these two can mesh together. So you can be a state officer employee and bid for a contract, and 73.7 at first blush may seem to not let you be able to do that. But where we draw the lines, where the commission has drawn the lines, and that is in 91.5, it says you can bid, but you cannot be compensated in any way for an appearance in support of the bid on the contract. So for example, you could not be compensated for appearing at a bidder's conference or for actually preparing or submitting the actual contract bid. So the circumstances in 91.5, there was a SUNY Stony Brook employee. That person was a sole shareholder of their own company. They submitted a bid for OPWDD contract. That was in compliance with 73.4. And in that opinion, the commission says there's no evidence to show that they were compensated for the submission of the bid, and so they were fined under 73.4 and 73.7. And when Aaron and I were preparing for this, it seems sort of odd when you think about maybe it's one person, a sole shareholder in a company. Maybe they're the only person that is dealing with their compensation, so they don't get compensated for the bid. That's how the commission settled it, but we're not sure how it practically plays out. I guess they just can't pay themselves for the money they get is from the contract, so that would be the compensation on the other end. But in 73.7, don't forget that this really, for the most part, applies to state officers or employees whose outside activity involves assisting or representing other people when they are wishing to obtain a grant with the state or a contract with the state. So, for example, there was a 2014 enforcement action. All our enforcement actions, as most of you know well are on our website. This is Daniels. It's from 2014. This was an ESD employee who was paid $15,000 by a private company to assist the company in seeking a grant from the legislature, and she was eventually fined $5,000 by the commission for doing that because it was in violation of 737. Also, when you are advising your employees, keep in mind 7312, and that is sort of a corresponding section to 737. So this is when it applies when the employee is representing a private entity such as a person who is acting as a member of a firm, an association, or the shareholder of a corporation. That person cannot orally communicate with a state agency. And then you go back into 737, and there's that laundry list of the things. So obtaining a contract with the state, or a grant or a loan with the state, licensing, there's a whole list of things that you cannot be compensated for when it's before a state agency. So just remind them of 7312 as well when you are advising your employees. So 7315 also comes into play. This is the section that prohibits a state officer employee from participating in any state contracting decision involving the payment of more than $1,000 to that individual or a relative of that individual. And when we look at the definition of the relative, it's the same one as for the 7314, the nepotism section, so just remember that as well. So if it's a rumor or sometimes a non-blood person living in that person's household, if they were going to participate in a state contracting decision, it takes that same definition of relative. Now, of course, 74, as you all know, almost always comes into play in any area of the ethics law that we're talking about. I won't read the general rule here again, but we have 74.2, the general conflict of interest rule. And let's get into a few advisory opinion examples. So we're going to discuss how the Commission has examined 73.4 and 74 throughout these examples. This one is kind of a doozy, so bear with me. All right, 9536. This is the advisory opinion. We had a SUNY hospital employees. Can they contract with their hospital or agency to provide services through a managed care network? So as you can see, 95, gosh, we're what, 25 years ago or more going back. But this is when several HMOs and hospital networks were approaching the SUNY hospitals about negotiating hospital service agreements for the benefit of their subscribers. Now, on the other hand, the SUNY hospitals responsible for appointing healthcare professionals for academic purposes. So they're bringing in doctors and whatnot for their faculty to teach. Now, the individuals, they also render services to private patients too. So we have their faculty at the SUNY hospitals, but they also most likely have private patients that charge their services for a fee. But when doing so, they weren't acting as state employees. SUNY, in this opinion, stated that they could not legally bind these professionals when they were acting in their non-state capacities to accept fee schedules or to require them to actually sign up and participate in these managed care networks. Opinion goes on to say, SUNY noted that the competitive bidding here was not appropriate. These were personal services that required a professional to hold an academic faculty title from SUNY and to have admitting privileges to the hospital. SUNY also indicated that the negotiation of the terms of the subcontracts would not be conducted between the institution and the individual professional. So really, this was the individual faculty, these employees, doctors, nurses, whatnot, who were negotiating with the networks. And technically, there were three parties to this contract. There was the SUNY hospital, the network, and the employees. The real relationship, the Commission said, was with the network and not the hospital. I'll just quickly read this quote. So the Commission in this opinion said to bar a healthcare professional from negotiating with or joining a network, because one of the papers in the three-way arrangement would be a purely boilerplate contract or subcontract between the professional hospital. It would be placing form over substance. So at the end of the day, they said, okay, 73.4 is okay, or 73.4 is not restricting these folks as long as SUNY, the hospital or the center, the university, exercise no discretion in establishing the three-way arrangement, and two, the arrangement or an employee's refusal to enter into the network had no bearing on the employment. So basically, 74 was satisfied if SUNY didn't have a way of getting in there and exercising discretion. A lot of facts there. So what have we learned? This is what we were thinking. So this is, you all work in so many different agencies. There's so many different kinds of contractual arrangements and services that your agencies provide. At first blush, again, this is 25 years ago when I think these were new arrangements, but the commission at the end of the day said they looked at all the terms, and even though the hospitals were technically part of this contract, they really examined it further and said that 73.4 was not violated. So closely examine all the terms of the contract. Here they focused on the business relationship of each of the parties to the contract, noting really, again, as I just said, that the employee doctors and the network were the real parties at hand. And whether you're reviewing employees' outside activity or assisting, well, should be your procurement department with ethics questions, you need to look at 73.4 and 74 at the same time to make sure both areas are covered. 93.10 is another example. Here, an SED employee, the question was, could they lease their home to OPWDD for use by OPWDD clients? And here, OPWDD advertised needing these leases in a newspaper, that this is the normal business practice of OPWDD when it leased houses. So here, the commission says, although they did not bid it out in the traditional sense, because real estate is a unique commodity, or what you want to call it, public notice and inspection of the property are, for purposes of our review, tantamount to a competitive bid. So 73.4 in this opinion was also met. The commission concluded that the state employee did not use his position to gain an advantage or use undue influence in the leasing process. So again, we have this non-traditional bid. But under 73.4, the commission found that it met the requirements of what could be considered a competitive bid in this area. And in 74, there was nothing to show that he was trying to use his state position in any way to obtain this lease. So what have we learned here? There may be non-traditional bids that JCOPE would consider meeting the requirements of a competitive bid. And as always, call us to discuss when there's a question. I've gotten quite a few recently about, well, would this actually be a bid or not? And these are things we are currently looking at as we speak. All right. The next one, 9111. Here, employees, they were on approved leaves of absences, and they, at this time, wanted to contract with their agency as certified family care providers in employees' homes. At that time, OPWDD had a specialized home service program that would allow only OPWDD employees to service these care providers. And in this program, they were paid by a stipend. Non-OPWDD candidates who wanted to also try to be try to sign up for this program were not allowed, and they were not eligible to receive this stipend. So this is a program only for agency employees. We have two issues here in 73.4 and 74 again. 73.4 in this case prohibited OPWDD employees from serving as these care providers. First, they were given a stipend, and in this, the way it was set up, did not allow these positions to be competitively bid without public notice. And so that was in violation of 73.4. The additional problem was the stipend was only available to OPWDD employees, and they were only eligible to receive the stipend, so 74 was an issue as well. Now, the same year, there was another advisory opinion, and this differs, 91-15. The question here was, could OCFS employees be certified foster parents? Now, unlike 91-11, the foster parents did not receive any stipend or salary for their services, and so there was no violation of 73.4a. Also, the Commission also addressed the potential 74 issue. Participating OCFS employees would only be able to receive the same reimbursement as any other non-employee foster parents who wished to do this. So there were no issues on either end there. 95-30. Is there a conflict of interest if an employee or his or her spouse were to bid on a competitively let contract that came from the unit in which the state employee works? So there was, I believe I did put it in here, but there was a bid for carpeting. And the facts presented here, the employee was completely screened out from the bid process, even though it was in the unit where she worked, as well as any consideration of the specs or the recommendations prepared by her unit. They totally walled her off from this entire bid. And the Commission then concluded that 73.4 and 74 did not prohibit the spouse, who's not a policymaker, from submitting, the spouse of the employee from submitting the bid to what would be his wife's unit, provided that the contract was let for public notice and competitive bidding, and then that employee had no involvement with the contract or the bid. And the Commission said because of the strictures of the competitive bidding process, the Commission concludes that there would be no appearance of a conflict. So here, something I think to take away is, with appropriate recusals and coupled with a competitive bid, it may allow your agency's employees to even bid on your own agency's contracts, unless, of course, you have a policy, an agency policy that says that's not going to happen at all. But without that, there is potential for that to happen. I'm going to turn it over to Erin. Anything before I get up? No question.
Any experiences that are worth sharing in your respective agencies that sort of have a bearing on any of the, either the hypotheticals that were raised or some of the issues or questionable practices that we're trying to support your ability to spot when they arise? Are there any stories that you can share about having to wrestle with some of these issues?
So for...
We've got a response.
Oh, okay. I just wanted to repeat for WebEx.
Oh, did you hear me?
I'm not sure.
Okay.
I just wanted to repeat for WebEx. So Keith asked, does anyone have any stories to share that have implicated any of these issues that we've discussed so far?
Well, would you consider a request for qualifications a competitive aspect? Like we have some of our employees have special training in, say, fire prevention, and other agencies have reached out to say, okay, we would like you to teach that fire prevention for a different agency.
So the question is, would a request for qualifications constitute a competitive bid in JCOB size? And I would say usually yes, anything that's formally that was the point of a lot of those not enforcement actions, advisory opinions, is that even though it might not be a bid that's over $50,000, that it automatically goes in the contract reporter, and it's easy to say, oh, that's competitively bid. There are going to be instances where it is going to give enough of a competition to allow it to go forward. I think we would look at it very much case by case.
So if there wasn't, so if somebody just reached out to one of our employees because they have those qualifications, so would you consider that a single source or sole source, as opposed to looking for qualifications?
So the follow-up is, would, if an agency reached out to one employee knowing that they had the qualifications, would that be considered a single source? Sitting here, I'm not sure. What do you?
I think you just,
Yeah.
I think in that scenario, you would probably want to just coordinate with the procurement department to figure out where in the process it is. So, could mean different things under the law. Typically, we look at if there's a determination of need that's been made by the agency, that typically starts the procurement process. And then the request for qualifications could come after that if it's following the typical, protocol, but it may or may not be.
Yeah.
So if sometimes you hear those words and you think, but I would coordinate with the procurement office so that you can.
So I would have to contact the agency who's contacting my employee, because they're reaching out from a different agency to an individual saying, okay, yeah, we want you to do this job.
Right. Or the individual could reach out. I mean, either way, whoever, whatever you decide is best. But I think that the procurement department from the agency that's reaching out is going to know where they are in the process and they probably be able to say pretty clearly if they're considering it competitive bid or not.
And if it was not, if it was considered strictly a
Single source, they cannot do that.
Thank you.
A couple of questions from our remote guests. First question, is the difference between the OPWDD and foster care cases the fact that employees were paid by OPWDD versus reimbursed for the foster care? So compensation question.
Yeah, I think what the difference was they were getting the services were not the compensation that was being given. It was not. How do I say this? I'm losing my mind. I think.
They looked at compensation. I think for the procurement discussion, what the advisors were trying to say was that those particular contracts, someone providing in-home services, you're rendering goods and services to the state. That in itself is rendering goods and services to the state, which is a unique example, unlike other types of services or products, that those types of activities are considered a service. And then second to that the advisory is differentiated between one instance that the employees were provided a stipend, which was considered compensation, and the other, they were provided something similar. And the commission touched on that only because in one case, the state employees were paid something different from non-state employees. But I think for procurement discussion purposes, that was sort of peripheral.
All right, another question. See, now my live guests are going to have to step up your game because our online people have asked 2 questions to your 1. So I'm just saying, it's not a competition, but I'm just saying. But this question is, what about a policymaker who endorses a vendor with whom we have a contract, not currently under bid, but will be in the future?
Endorsing how, I wonder. And we get questions about can I give an endorsement? We have said that would typically be prohibited under 74. That you can give a testimonial as to what services were provided when, but when you say something like, and they were the best company.
The policymaker is endorsing that vendor on the vendor's website.
That's a problem.
Okay.
I would say that's a problem.
They don't currently have a contract, but they're considering doing a contract with them.
I think that when you think about how we talk about vendors, and even in the gift area, an interested source is considered a source that is either contracting with or seeking a contract with your state agency. And so when you think about that globally, absolutely, if they're in the contracting process and they have an endorsement on the website, I think you're in 74 territory. Call us. Or not. Deal with it at your agency. No, I mean, or, deal with it within your agency in a way, but I think that is a problem.
Okay, thank you.
No, call us, really. All right, here's Erin.
All right. Is this okay to place the stand?
Yeah.
Okay. Thank you. So another way that we can look at how the Commission has applied the public officer law sections we've been talking about to these contracting with the state scenarios or through enforcement actions. Here's one example. So this is meant to provide background. We're using this for discussion purposes. So assume that you just get this information as an ethics officer. You have a university professor who initiates the procurement process. This person does so by writing a sole source memorandum, and he's pitching this great idea about a fantastic research software product, and he sends that memo to his own agency, the university, and also to another agency that's involved in graduate research. In this enforcement action, it was the dormitory authority. So he sends these memorandums along, and in the end, it ended up being DASNY who issued payment in the amount of $45,000 for this research software. So how does this look so far?
Throw it out to the group.
Those of you who've trained the CETC before.
Yes.
So, like, look into what firm was recommended and see if there's any obvious conflicts. Are there relatives, or spouses, or other people involved that might present, conflict of some sort?
Okay.
Whether, getting a financial benefit from it. Did this professor receive any money from the firm as well? That would be appropriate.
Right.
That's the first thing in front of mind.
Right. Okay. I'll just quickly recap it. The audience member was in more detail, but I'll summarize that we should look into, who submitted this. Who did he submit this memorandum on behalf of? Who's the company? Who owns it? Who's a part of it? Is it him, family member, or someone else? That might sort of clue us into who's going to be getting that financial interest. So thank you. Yes, in the back.
How do we know for the issue an RFI or another sort of performance device in order to see if there's a bigger field of people out there?
Right. Question is what did it look like? What sort of triggered this response, and what is this procurement related to? Absolutely. I saw another hand, but maybe change of mind. Okay. Those are great things to look into, and this is some additional information that you've touched on that could be helpful. So we know a little bit more now through this enforcement action. That the university professor is the owner of the software company. He's actually the president and was on the board of directors of the company. He opened up a P.O. box and a checking account prior to receiving the payment that came from DASNY. This notes that this was the only sale of the software company has ever received, and similar vendors were never reviewed, and advice from experts was never solicited. And I think that the memorandum that this person prepared and sent along sort of indicated that this is a unique product and no one else has this product and that type of information, and then it turns out there's really no other, there's no basis for that. So in this scenario, what is the relevant information? You touched on, who has the company, where's that coming, where's that contract, who's that connecting back to? Is there other information that we haven't talked about that you think would be helpful? Yes.
You suggested, like, comments back here that what's the basis for the specifications? Are the specifications artificially sole source
I'm reminded of ancient history when the Crown Victoria, Ford Crown Victoria was the gold standard for state police cars, years and years and years, and it turned out that the specs were written as though that was the instructions on how to build the car, and yet the Chevy Impala and other vehicles that are used now would have done the job, and that contract got tipped over for a while because of that. The specs were artificially rigged to a single product.
Right. That's a great point. You would want to look at the contract specifications, and I looked at it pulled up the enforcement action and was reading through what was contained in there, and in the it's a settlement agreement, so it's what the professor admitted to, and it did not talk about how the contract was initiated, how the process got initiated. But the way that it was presented was that he, he had a company and he pitched his idea. He knew a research grant was out there through DASNY, and he pitched this idea and didn't tell anybody about it. So,
Yes, he did not identify, from what I remember,
Oh,
he
right.
did not identify himself as the owner of the company.
right, that would have been
helpful.
That would have been helpful too. So that's number 2. What steps should the professor have taken? I think disclosure, definitely. If anyone has any other thoughts on what the professor should have done. What about standards of conduct? And this is under POL 74. Which standards of conduct do you think come into play in this case? Is the code of ethics.
Conflict of interest.
What's that?
Resort to.
Yeah, that's right.
Famous chart.
I have a great chart next to me. Right. So there's a securing unwarranted privileges for himself by doing so. He clearly has a financial interest in the company. He's using his state position to benefit financially, and then just sort of the general violation of public trust, I think, comes into play. And then what other ethics laws may have been violated? And this is touching on 73, some of the other provisions that we've talked about already. And this would capture, so the settlement agreement, he actually admitted to 7315, which prohibits state employees from being involved in the decision-making process with respect to contracts. So that would apply, as well as 73.4, since it was not competitively bid. And the consequences for this state employee, he did enter into a settlement agreement with Jacob. The fine was $20,000, and the value of the software he paid back as well, for a total of $65,000. Is there another PLL section he may have violated? I like that. Yes. We didn't. Okay, we're going to add that to. Maybe we'll add that next time to the slide. So the someone mentioned their financial disclosure form comes into play. Absolutely. So that would be outside income, and this business would have, if you were a policymaker, it has to be reported, or a special filer. Position. Right. He served as the board of directors and president, so all of that information will have to be disclosed on his financial disclosure form.
Also, that's a great point. Also, another area is maybe that they've disclosed their company, but leave certain information out on the FDS. So I have ABC company, and I make widgets, but then they don't identify what state agency. So always make sure, if you have a question, to make sure that your employees are filling out their FDS completely with all the pertinent information.
No, it's fine. I needed that. Right, the outside, that's a great thing too, to look at whether or not it was approved in the first place, or whether or not if it wasn't, intended, if it wasn't required to come to JCOPE even internally if it was approved. I don't think the settlement agreement touched on that, so I'm not sure with this enforcement action, but absolutely, outside activity request would be something to look at too. Great, thank you. So I may have said this one already, 73.4, so sorry if I spoiled. But we're tying it back to Megan's presentation here, and we're going back to this concept that even though state finance law allows for agencies to put out these types of bids that are sole source and single source,
you know, oh, this is a resource, I'll go back. It seems like most of, you know, in your role where a lot of these questions are going to come up are going to be either before someone enters into a contract and you're going to come across, you know, the scenario before this happens and be able to identify and address it, or you're going to, or it's going to come across your desk when someone either already has entered into a contract and maybe there are ethics issues that arise in your role as well. And we want to talk about both of those different scenarios. One of the things we thought would be helpful for you is to point you to a couple resources. One of them is something put out by the Comptroller's Office. If you go on their website, Megan knows best, but it's called the Statewide Financial System, SFS Resources. And they have resources for vendors and agencies. And this is an excerpt from one of the resources that they put out for agencies, and it just kind of gives you, you know, a snapshot of what's contained in there if you wanted to take a look. And this is sort of best practices for agency managers. What can agencies take a look at? And one is internal controls, if you don't have them already, to ensure compliance with the public officers law, and ensuring that employees are familiar with their obligations. So that's a good resource. We also thought we'd share with you, Megan did all of this great research on what agencies already do. So you might be working with some of those agencies, or maybe it just gives you some ideas for things you could do at your agency. So this is general standard language that shows up in all New York State contracts. And this is just something you may already be familiar with it, but this is sort of on the, most likely on the procurement department side of your agency. And what this shows is that there is reference to Public Officers Law 73 and 74, but it's pretty general. It doesn't talk about the provisions, but there is information in there. So when you're thinking of contracts that you're coming across your desk, you know that this is standard language in New York State contracts. This is an example of the Education Department information. So this is their procurement department as well. So in addition to the language on the prior slide, the Education Department has an additional, it's an additional appendix. And in that appendix is a certification that a contractor has to complete to say that they are in compliance with Public Officers Law 73-4A. So that's another example of another agency there. So I mean that it's great. It's just more notice. This is another in terms of enforcement action purposes to have that certification is good too. Someone's acknowledging that they read and understand the law. So another example is from SUNY in their procurement. On their procurement side, they have a form that the campuses use, and that form is an acknowledgement of that they are, in compliance with Public Officers Law 73-4. And what's interesting about this form is that, and the last paragraph on the slide talks about that, is that the procurement department responds accordingly based on the information that they get from that form. So if that information on that form says that the person is a state employee, then they will make sure to use a formal competitive bidding process. That's going an extra step further, but that's certainly putting in place a safety mechanism for compliance. I have to get water. Sorry. Okay, so this is another form. This is another SUNY form. This is an example. Buffalo State has on their website the language right from the statute. So you can have that information if you haven't read the Public Officers Law booklet. This is Stony Brook, and they have statutory language as well.
anyone, maybe this is a good place to ask if there are any agencies that want to brag about themselves at the ethics forum and all the, if you know about what your procurement department is doing?
I don't think it's bragging, but at State Park, we have a lot of, we go out and we don't competitively bid a lot of purchases. And so we used to do it by getting quotes over the phone, but now we do it through email. And in the email, we just say, if you're a state employee, this is not competitive bid, there's no public notice, do not respond if you're a state employee.
Oh.
And keep it very lay terms,
Mm-hmm.
that it works, yeah, that's all that we do.
Okay, that's great.
Would you summarize that?
Sure, I'll summarize. So the so Office and Parks. What's the formal title of your agency?
Parks, Recreation, and Historic Preservation.
Parks, thank you. Recreation and Historic Preservation. They instituted through their contracting process that communication that they do through emails. They indicate in their emails when notice goes out of a contract that if you're a state employee that you're obligated to abide by an inspection of the Public Officers Law.
Well,
with
we tell them
respect
don't
to,
even to respond because it's not competitive with bid or publicly.
oh, got it. Oh, okay.
So we don't, we'll just call up for quotes in the past, but now we just send out emails to a couple businesses in the local regional area.
Okay.
And since it's not publicly noticed or competitive with bid, we just say do not, if you're a state employee, do not respond.
Okay. All right. They say do not respond if you're a public employee when the agency knows that it's not competitively bid. Great. All right. We'll add you to the slide for next second time then. Anyone else have any? So, I mean, the thought was to share with you, because when we get questions about these types of scenarios with employees contracting with the state, we end up diving into the procurement arena. And so we thought that these types of resources would be helpful because it gives you some sort of background. It gives you a sense of, maybe what questions to ask, what, could potentially raise a red flag. Certainly not trying to create more work for you, but I think that, if there is an opportunity to collaborate with the procurement department in your agency or be able to reach out to them if you have questions, even, technical questions or procedural questions or things like that can be really helpful in trying to, maybe they can give you a quick answer that can, alleviate your concerns or, present more questions for you. Or you can call us as well. But it's just something to think about. So I'm just going to, now, sort of move into your role as ethics officers. Sort of now that we have this understanding of what things are out there in the procurement arena, what can you be looking at? And one of the things that that you could do is coordinate, train, work with your procurement department. And this looks different for everyone. Some agencies are already doing it, and these are just suggestions. So first, on sort of a macro level, we're talking about just talking about procedures and internal controls, sharing with the procurement office some of the things that may come up as ethics issues. Maybe talking about, because every agency is going to be different. What types of contracts are the most common? What issues come up? Maybe there are ways that ethics officers can collaborate. Maybe the procurement department can provide you information on, what non-traditional bids look like. Look at some of the other examples that we've had. It looks like and Megan and I both had this come up, where people have called and asked about purchase orders or purchase orders contracts. Is that in I think in the instances that we've looked at, they have been. So that's something that if you haven't already, your procurement department can sort of lay that groundwork for you. And I think it would help in looking at the issues that come across your desk. If you would like, you can use your collaboration with your procurement department as an opportunity to let the procurement department know that there are ethics rules for them outside of the context of the rules that we've been talking about. This is just for your information. Those ethics rules are described at the bottom about gifts and conflicts of interest with respect to vendors. And then this outside activity regulations, this is probably the forum where you're going to see most of your procurement questions, I would imagine. So we can, this is sort of when you're looking at it on a smaller scale, when you're either someone comes into your office and wants to know if they need to get approval, or they have something in mind and they're looking for formal approval. These are some things that that will come up. You already do this. Look at whether or not the person's a policymaker. Looking at the nature of the contract. So sometimes even in the outside activity approvals that we get, we'll see a name of a company, and unless it's identified in there, we won't know what the relationship is between the individual and the state employee and that company. That's something that you all can do. I'm sure you do it already, but that is something that you can do is to, are they the owner of that company? Is it a family company? Maybe it's completely unrelated, but, then that sort of spurs, more questions and more things to look at potentially. Or we have instances where maybe they're not an owner of the company, but they have a financial interest in the company. And that information is important too. So, and then for the procurement aspect, you would look at the type of bid and the parties and other terms of the contract. And sometimes at first glance, it's not clear, when you have more than two parties, exactly what that, focus of the contract should be. And you can call us as well, but that's something we look at. Let's see. Yes.
I just want to jump in because a question came in the text chat for me, not for you, but it's worth sharing. The question was, will we be making this PowerPoint material available on our website afterwards, because this person would like to turn this material over to their training department so that their ethics trainers can do a little bit of training for their procurement department. Yay! And so the answer is yes. We are recording this, and we are going to be making the recording and the PowerPoint available on our website. We do that with all of our forums. Give us about a week to get that uploaded, but this material may be of particular interest to you, and you may use it for those purposes.
Great, thank you. Well, I'm glad someone was encouraged. I thought I was sort of, making it more difficult. But so, and so, what if you have an individual who's not a policymaker? I think it's a little different. Well, I don't know. Maybe the audience can share with us. Do most agencies have policies on non-policymakers in terms of either just notifying the agency of outside activity or notifying and/or getting approval of an outside activity? Yes, most of them.
We do. We send our Human Resources Department sends a reminder out every year that employees have to renew their internal permission to continue doing an outside activity. It may just be confirming they're still doing it, reminding them that they stopped for a period of time, they have to request again to initiate it.
Okay. Do the ethics officers, do you see those non-policymaker outside activity approvals or notices? You do? Okay. All right.
Yeah, and OCFS has a broad policy on outside activities. I've heard anecdotally that many agencies do.
Can I ask, what agencies are you guys from? Are they large, big agencies? Yeah. Okay, so that's great, because I think some larger ones it would be harder to have a policy like that. When I think about docs.
Yeah, we have to,
Yeah.
being regulatory agency too, and make sure that the employees aren't out there doing things they shouldn't be doing,
Right.
because we regulate so many people. Yeah, I do see it.
That's great.
At the New York State Insurance Fund, so we really need to. It's a big agency. And as part of the training, I just say that
ITS notes that they have a robust policy for approvals for outside activities, particularly since so much of their agency work product is dealing with contractors and business owners and website developers. So it does make business sense in that regard.
That's great. Good. Well, if you're not doing, it sounds like a lot of agencies are already doing it, but we threw in a recommendation to do periodic e-blast to employees or whatever form of communication that your agency uses to get that message out, even if it's just sort of reiterating this concept that if you're engaged in anything outside of your state job, even if it's unpaid, that you should be seeking approval, making sure that that's in compliance with the public officers law. That's okay. So you can do training for all employees, emphasizing 73.4. That's in the CETC training, so that goes to all the SDS filers. Ethics reminders, and I think we talked about ideas from other agencies. Is there other training that any of the ethics officers do in terms of outside activities specifically, or when you do it, is it all together, public officers all together? Yeah.
Yeah. I was just going to briefly mention too that for GOR agencies, that we call it the Ethics for All. I know it's not called that, but they recently put out a training for all employees to take, and that for FDS filers, they have to take it on the off years. They're not doing their JCOP required training. They do mention 73.4, but I think to our point, just in any way you can, especially sometimes for the GOR training, I think a lot of people know that they just click through to get to the end. So to have other ways to make sure that they're hearing from you regarding this, because this is one of those, all these 73 sections are applicable to everybody, no matter whether you're a policymaker or not. So,
thank you. All right, so we had, if you have hypotheticals, now's your time to share them. I know it's a busy time of year, we understand, so that's okay that you didn't share them ahead of time. So I'll go through one that we came up with, and then if you have other ones, just for discussion purposes, let us know. So in this hypothetical, here, the ethics officer in your agency, your procurement department notified you that an employee from your agency has entered into several purchase orders for training services with your agency. What steps should you take to ensure compliance with public officers law? So what do you think when you hear purchase orders? Credit cards? Okay. And low, okay. The dollar amount might be,
But you still need to have all the vetting that goes along with more expensive purchase.
right. So would you reach out to reach back out to the procurement department and find out exactly what is it, how many, what is it about, what are the services, training services, right, you'd want to know the number, the dollar amount, how long has the person been doing it?
How did we get there? What course did we take to get this individual?
Right, and maybe, and every case is different, so sometimes it is important to sort of work backwards as to how did this come, why did the issue arise, right? What happened to sort of maybe trigger this notification, and that could be many different things. So, and then, you could work backwards. So, and then going back to one of the other points mentioned today, you'd want to look at, did the, employee get approval? Did they, in any way, shape, or form, did they let their supervisor know? Did they go through their, agency procedures to get approval?
Well, would you recommend contacting the employee also? Is there any downside to that as an ethics officer? trying to discover whether procedures were followed? Who thinks yes? Thank you. Right answer.
Well, one thing, one of our notes says, check their filing status. If they're a policymaker, they should have be seeking approval for something like this. It would be an outside activity. If they have a purchase order contract with another agency over that $1,000, at least they would have to. If it's over $1,000, they'd have to come to at least you all for something like that. So, yeah. One thing to think about.
What about the purchase order itself? Is there anything that you would want to know about, the process? Right, was it? Right.
I'm not an attorney, I just work in HR and maybe I should be why. I'm not being an attorney, but I don't know. Not a lot.
No, absolutely. What was, was it competitively bid? How is it put out?
Another thing is just out of a sense of paranoia, is the purchase being segmented into small purchase orders rather than a larger number that would require OSC review and other scrutiny.
Right. Right. Is there anything about the, if there's more than one, is there anything that would lead anyone to believe that was done intentionally?
Do you ever want to see the purchase order itself? Is there any value in seeing the actual document?
Our rationale is only that, anything that happens is potentially auditable, and even though the audit may be like a lightning strike, very infrequent, and so on, that's the rationale to scrutinize things.
I think you've summarized a good life philosophy. Act as though you may someday be audited. That kind of fits
I do like that.
All right.
I do like that.
Or have been audited.
Act as if you've learned from your mistakes. Let's move on.
Well, I think, let's see. Sorry.
No.
No, that's okay. Okay. Okay, so, and this is assuming that we go through the proper protocol on this scenario and this employee seeks approval to engage in this outside employment. Can you have an employee who contracts with another state agency to provide training services? For compensation, yes.
Wasn't there at least, let's say I become an expert in a certain area due to my experience as an employee of this agency, and then somebody calls us up and says, hey, can you provide us training in this area because we need people to be compliant in the rules that you oversee or whatever. And so I said, sure, just give me $500 and I'll come and do it. I feel like obviously there's a conflict there because you're performing your duties as a state employee for additional compensation.
Yes.
Maybe you should be doing it just under your normal business practices and not for additional compensation.
Yes.
That's one scenario, I think.
Yes.
You win the prize.
Yes.
You mean I can't freelance as a statewide ethics trainer? There goes my Christmas plan.
No, you brought up a great point, and I'll summarize for WebEx if they didn't hear you. And that's exactly one of the things, that's exactly what comes up in these scenarios is when someone obtains a skill or expertise in their state position and they want to carry that over to an outside activity, can they do it? Correct me if I'm wrong, so Commission's guidance is that you cannot engage in an activity if your agency would otherwise expect you to do that, perform that same training or service in your state capacity. Even if, like, let's say you don't even do it now, today. If your agency could say, that it's possible that they might expect you to perform a certain kind of training, at some point that's within the scope of your duties, then you would not be allowed to engage in that as an outside activity. And that does come up. That's usually where we see that too.
That's not really the question, right? The question is doesn't really go to that, and I think the answer to your question is depends, but generally, yes.
Well, let me go to the next slide. I'll show you what I put.
We had a-
Yeah, go ahead.
If it was not another state agency, it's a private entity, you know what, how does it change it that it's a state agency? Does it change?
So the obligations under the P&L sections that we've talked about would,
So if it was a private agency, then it would be okay?
and so the example is training services.
Right, so like people in my agency become experts in workplace safety, and they get certified, you know, and then that's an expertise, and then they say, well, okay, can I go out and provide that to businesses then, as an outside activity?
Yeah, I think that, and I'd have to look them up, but I think there are a few older advisory opinions that talk about you cannot trade in on your public service to make money on the outside. So you can't use your expertise while you're currently working as a state employee. I
So
think.
absent advisory opinions, is there any provision of the public?
I mean, I think that hits on 74.
Right, well, 74.
That's the catch-all for everything.
So
yeah.
no specific provision.
It's 73 now. I don't think. Yeah. I think there's one about. There's a DEC one about forestry. I mean, it goes to a bigger concept.
It's sort of a spin on, you know, employment restrictions when you leave state service.
Yeah.
It's sort of a spin on that.
Oh, I thought I had any thoughts. There you go. So, yeah, so that I think that one of the other answers to the prior question, when we're looking at whether or not someone can do it, you look at you analyze it under 74, to answer your question, sir, you analyze it under 74 and see if there are any conflicts of interest. But one of the things that does come up that we do look at is, potential conflict of interest is, do you already perform those same services in your state job? That's an example of a conflict, right? So it could be other things. It could be that the business entity, that you want to, well, I guess this would be another agency. But there could be overlapping, duties and responsibilities that, you'd want to take a look at. Just make sure that there are no 74 issues. Anyone else have any questions? Yeah, so the question was with respect to agency approval of outside activities, when your agency has a policy that every employee should provide notice and get approval for any outside activity, if it's unpaid or unpaid, helping out with coaching or involvement in your church. The question is whether or not the activities relating to any religious activities, do those, is there sort of a concern about whether the agency should be involved in approving that? I think I've had that question once. So we didn't, it wasn't approved, it wasn't an example that JCOP required, it didn't require JCOP approval. Yeah, so we didn't, I recall that we did speak about, what implications that would have for the agency. I recall we deferred to the agency, and I think that they ended up not, I think they worked with the person on it. I don't know if that was something that they pushed as being a requirement. In that context, there were other legal implications, I think. But that's all I recall about that example. Yeah, I'm sure it probably comes up. Keith, do you know if there is?
I don't.
Okay.
It would really be the agency's call,
Yeah.
depending on what internal policies you've got there. There's always the ability of an agency to impose more strict requirements than the JCO.
That's scary.
Right.
And it could be also have people.
Right.
Somebody specifically asked me a question.
Right. And maybe even to maybe council's office could sort of, I don't know if the notice, requiring someone to provide notice that they're engaged in that, that might be okay, but maybe, having to get approval, that might be the issue. I'm not sure. But, all right. Any other questions from the
Just a general request that perhaps JCOPE could collect sample policies or best practices from various state agencies and make them available. And in the interest of sharing, I would point out that is one of the reasons why we hold these ethics forums is, we're all so siloed in our own agencies. Sometimes it can be hard to share best practices. So this is at least one shot at you all professionally having an opportunity to discuss topics of mutual interest.
And send us anything that they
I was
like.
just going to say, please.
So I would say if you're participating today or if you are watching this broadcast at a later time and you have a policy, agency-wide policy that relates to outside activities or relates specifically to today's topic about employees, please do send that to us. We'll compile it because anything that we can do to help support you in the efforts that you play in helping make ethics better in New York State, we will certainly do what we can to help facilitate that.
And I'll just make one more comment about that, actually. So there's not some voice from behind the great Oz. When I was doing the research to see what agencies already do about this particular section, of course I didn't go through all, 350 or so. But I did notice that, and I won't call out anyone, but there were quite a few agencies that didn't have anything at all, probably for their procurement department, for folks who are going in to bid. So maybe today that would be great if you sent either to legal, probably education inbox, if you have any samples of things that you do, to Kate. Yeah, Kate and Brianna will go through that stuff. I think these were created, again, I probably say this every time, these were created, these forums, to have you all be able to come together and learn from each other, and us learn from you, too. So that's great. Thank you. Anything else? All right. Thank you all for being here today.
Thank you.
All right.